Mr. Meyer.
May it please the court. Good morning, my name is Darrell Meyer. I'm from Marshalltown and I represent the applicant defendant Stephen Prusha. Mr. Prusha was convicted of a serious misdemeanor possession charge based on a warrantless search of his person in connection with a community caretaking encounter with a county deputy. The state has claimed that Mr. Prusha gave consent to the search. So this appeal presents two questions to the court. One, was Mr. Prusha's consent to the search of his person valid under a multi-factor analysis? And two, perhaps the more interesting question under the Iowa Constitution, should the court recognize constitutional protections requiring law officers to advise citizens that they may refuse a request for consent to search, at least in the context of community caretaking? Preliminarily, the state's brief raises a couple red herrings in whether this case involves a search or seizure at all. And we can dispense with those because in Reinders it's clear that a search invokes constitutional protections, and so there's no question that we have to go through the analysis in this case. But second, the facts here are sufficiently clear that this is not a plain view case as suggested by the state. Here the officer initiated the search with a request for the search, and to say the contents of Mr. Prusha's pockets were in plain view once emptied only begs the question why the pockets were emptied in the first place.
Counsel, I understand you're relying on Reinders in part, but wouldn't we need to overrule Reinders in order to require an affirmative disclosure of the right to say no?
No, because in Reinders, the result in Reinders doesn't necessarily extend to what is being requested in this case, because in Reinders it was a Terry stop, and the individual had admitted that he had weapons. So there was a legitimate inquiry about weapons. He admitted he had them, and then that led to what followed, the subsequent other items.
But in Reinders we said, quote, the validity of consent does not depend on a particular defendant's knowledge that he had a right to refuse permission to the search.
And when you say dependent, meaning that if we can establish that there was no knowledge of the right to refuse, that would end the inquiry. The question's over and the consent is invalid. And I guess we can jump ahead to the second question. Is it intellectually satisfying enough that our laws require that in order to enter a guilty plea, we make sure that an individual knowingly waives the right to trial? Everything is waived but the right to counsel. We also require that when a person waives speedy indictment or speedy trial, that there's an inquiry, a colloquy, where the person knowingly is giving up a constitutional right. Even in contracts, when you're waiving a right, you are relinquishing a known right. Now somehow we go from the plea and the waiver of speedy, even on Miranda, the right to not answer interrogatories by police in a custodial situation, then we kind of skip over this consent.
But under that reasoning, wouldn't you in effect extend Miranda outside of custodial interrogations to any encounter where, hey, what'd you do? What happened? And then if the defendant makes an admission or confesses, it's not admissible because they weren't told up front? You have a right to refuse to answer my question?
I'm not suggesting that the relief that's being requested here and the advisory that we're asking the court to endorse, that doesn't replace Terry. And so it's somewhere beyond Terry. If this officer in this case had patted Mr. Prusha down, he may have discovered this pipe, which then would have led to a little more investigation. But he did not do that. This is not a Terry case. And so in cases that...
Isn't it less intrusive to ask him if he'll consent to a search than to pat him down? I mean, when you go to TSA, you go to the airport, they ask you, please unload your belongings. If you don't do that, they'll pat you down. That's considered more intrusive, right?
And when you buy the ticket, you're expecting that. But when you're walking home on a rural county and you're accosted or encountering a deputy sheriff, then the coercion has begun. This occurred at 1:20 a.m., 3 miles out of town on a county blacktop, and the officer had passed Mr. Prusha, then came by him again, and then turned around, and in the flood of the headlights, he's now encountering the deputy.
But your legal principle isn't limited to that circumstances. It would apply to somebody walking right outside the door, outside in between here and the Capitol at 1:20 on the morning, where they sent in the computer check and it came out that he's on a terror watch list. That would apply to that person too, right?
I want to make sure I understand your question. If an officer wants to investigate and ask questions, there wouldn't have the advisory wouldn't apply. The advisory is only going to apply to a search of the person.
I agree. If the officer wanted to search this individual, he'd have to say whatever advisory you want the officer to be required to give. It applies in all circumstances, right? That's what you're asking for, a general rule.
I suppose that's the logical extension, but in a community caretaking situation where in all these cases we're balancing individual liberties versus the public's interest in crime stopping, crime prevention, and in a community caretaking situation, even the state's brief acknowledges that this is not a crime stopping situation. This is a community caretaking situation. It's supposed to benefit Mr. Prusha. Now, if I'm going to get patted down at the Capitol building or leaving the building today, if it was community caretaking, that would be unreasonable. But if there is some reasonable suspicion, I'm on a list or something, or someone has whispered something to the bailiff before I leave, then I don't think that we're in a community caretaking scenario. So the court can limit this to community caretaking when the individual interest should clearly outweigh the public interest in crime stopping, because community caretaking is to benefit Mr. Prusha, and this situation clearly didn't serve his benefit.
May I ask you a question on the record? At least based on my examination, it didn't seem like you raised Iowa Constitution at the district court level. And the reason I say that is I did examine the district court order, and it seemed like the district court order was based solely on the Fourth Amendment. And I didn't see in the appendix materials, at least, any briefing, nor did I see any expanded findings. So I'm just asking you a question that relates to our preservation doctrine. Ordinarily, we require that the Iowa Constitution be raised below, and I guess I'm just not sure that it was, but you may be more familiar with the record, and I invite you to share with me how it was.
I apologize, Your Honor. I don't recall in the record if there was a specific, I know it wasn't briefed. These probably would have been just oral arguments made after the record was made with the officer on the stand. I will just let the record stand, but the state has not objected. I think they consented that error was preserved, and so I think we're here on that acknowledgement by the state.
Well, Counsel, as a practical matter, looking at your motion itself, you, in paragraph 2 of your motion, you assert that the search was in violation of the statutes of the state of Iowa and in violation of the 4th, 5th, and 6th Amendments to the Constitution of the United States, but not, so you don't specifically challenge the search in the text of the motion based upon the Iowa Constitution. I looked at the hearing transcript, and there's no reference by either of the lawyers, yourself or the prosecutor, to any specific provisions of either of the constitutions. So with the benefit of that supplementation of what the record shows, what is your best argument with respect to why the advisory that you're asserting here should be the rule, was raised under the Iowa Constitution in the district court?
I would argue that the statute is a reference to the word statute, maybe wasn't the best language to use, that it would broadly cover Iowa law, including the Constitution. The Constitution has been codified, and so if we can take the term statute to mean what's been codified, and that would include the Constitution, I think we're able to get there on the error issue.
You think the court was fairly on notice that you were raising the Iowa Constitution?
I believe it should have been when there was a reference to statute, that should have tipped off the court that it was something other than the U.S. Constitution, and therefore we'd be in considering Iowa law, which
You just have a limited time. Why don't you make your best argument under federal law, under Schenkloth, that this search was not consensual?
right, and good point, Your Honor, because this court can at least save Mr. Prusha without adopting some additional protections. In this case, he was detained. Clearly, the coercive nature, the stop itself was a detention, and it was only an afterthought that the officer then said, hey, by the way, you got any stuff on you? You got any weapons? It was an afterthought. The contact was over. There was clearly no safety question. And so we had a detention. We had a show of authority. He was not advised of his right, which is a factor under the multi-factor test. And the purpose of the stop had concluded, but he was not told that, well, okay, I guess everything looks kosher here. There's no warrants for you. There's no situation that raises my suspicion. He should have been told that he's free to go at that point. And he was not told that. It suddenly turned to a request for a search. And so under the multi-factor test, we still can overrule the district court and suppress this evidence, and that's what we're requesting. Thank you.
Thank you as well. Ms. Huser?
May it please the court, counsel. This is a search and seizure case with neither a search nor a seizure. When the state raised those arguments, they were not red herrings. The facts and the law support the lack of a search and a seizure. But before I dive into that, I would like to discuss this error preservation issue that has been raised. It is true the district court did not rule based on the Iowa Constitution, and it was not really as below. The state did concede in its briefing that error was preserved. However, I would acknowledge that this court before has recognized that the state's concessions do not necessarily limit it from deciding that error was not preserved on the Iowa Constitution issue. I'd like to start with the seizure. The defendant in this case was not seized. A police officer can approach a person and ask questions. He can even take an identification and check for outstanding warrants. These actions are not a seizure under our case law, and I think that's important because if we don't get to a community caretaking stop, the limited request that the opposing counsel asks for doesn't come up. He's specifically asking a community caretaking context. We don't have a community caretaking stop.
Wasn't the community caretaking function achieved already prior to what is characterized at least as the search? I mean, there was the initial inquiry, and he did, the officer did, kind of go back to squad car and learned some information about the person, asked him what he was doing, so forth and so on. But it seems to me the community caretaking purposes were over at the time the search request was made. Tell me that I'm wrong and point out what in the record suggests that I am wrong.
Well, the first distinction I would make, Your Honor, is though he may have stopped with this caretaking function in mind, the caretaking stop still requires a seizure, and the actions that the police officer conducted were not a seizure because Reinders and Smith both say you can ask for an identification. That in itself is not a seizure.
But it's all done. I mean, I get that, and but again, and I may be misreading the record, and you're more familiar with it, so I'm asking the questions. But so sure, you can ask for identification and do some preliminary checking and so forth. But there's a time element, I think, and it seems to me, as I read the record, that the community caretaking function, I mean, what's he doing out on the road at 1:20 in the morning? I mean, I think the stop, frankly, is fair. I mean, officers driving around, here's some guy out 1:20 in the morning. Of course, you stop and check and find out what's going on. But hadn't the officer kind of completed that and then proceeded to the search, and does that give rise to a problem?
Although I continue to challenge that it was a seizure, assuming that it was community caretaking, yes. I believe it ended at the point where the mission of that was complete, where he said, "Are you okay?" And he responded, "Yes, you are." However, under Smith, that is what I would rely on, that a seizure can conclude and then no new seizure can start if you have the actions that happened here, the identification, the warrant check. That was not a new seizure, because as this court has recognized, those actions do not create a new seizure. And that...
But why do we care if there was a search? Why does it matter whether there's a seizure or not? I mean, aren't we really arguing about the search?
Both were raised. I think the reason I'm focusing on the seizure is what is being requested as a per se rule is that it's related to a community caretaking stop. And so I would challenge that if there was no stop, the per se rule that's requested doesn't matter. But to turn...
There was a stop at some point. I mean, they're all kind of wrapped in with each other. Once the individual gave consent to the search, he was being stopped because the deputy was in the process of walking him back to his car, correct? To do this search, right?
Yes. I would say at the point that he consented, he chose to then follow the deputy to the car. But to get to the consent part, as this court is discussing, under the totality of the circumstances, there is a valid consent here. We look both at what happened and what didn't happen. Here we had a police officer. He did not have his emergency lights on. He did not have his siren growing. He did have amber lights on, but that was more as a safety issue because of the side of the road that he was on.
Well, let's grant that that's true, but from the perspective of a reasonable person in Mr. Prusha's position, is it really necessary or is it appropriate to distinguish between the color of the lights, whether they're amber or red or blue? I mean, from the perspective of a reasonable person, if the patrol car's lights are on and you're being confronted by an officer, does the color of the light really make a difference?
It does, because that is one of the factors we look at for coercion. When the lights are going, there is some sort of the traffic stop type mentality to it, that this is inherently a more coercive situation. When the lights are not on, it conveys what happened here, that we're just checking to make sure you are okay on the side of the road. Further, I believe it is Wilkie's where even the headlights bathing the defendant in light, that in itself is not coercive. Other factors that indicate that this was not a coercive scenario is there's no indication in the record that the police officer used a tone of voice, exhibited his weapon, did any of the sorts of things that we would see as threatening, as intimidation. Instead, what he said was, "May I search your person?"
Were we proceeding back to the car at that point? I guess I want you to clarify for me the record. We were out there in the middle of some road late at night. Then after he goes and does the check of any type of warrants and gets this other information, does he then go and retrieve him and bring him back to the squad car?
No, so to set this up, the defendant was walking westbound on the road, and the police officer had turned around and was facing him. So the police car was facing the defendant. It was about 75 feet between them. The police officer went back to the car, then went back to the individual. He continued to walk the same direction that he was walking. So it wasn't, and I think that's important because it wasn't the police car is parked the opposite direction from the way he was walking. He continued to walk the way he was going back towards Marshalltown.
Didn't he go to the other side of the road?
Before the police officer interacted with him, yes. So
But
at
he's
the
not moving at the direction of the officer, is your point. He's simply continuing on his path.
well, he was moving towards the officer because the police car was parked in the direction that he was
But
walking.
not at the direction of the officer. In other words, the officer's not saying,
No.
come with me, I want to take you up close to the car so we can
Correct.
search or do something.
That is
Okay.
correct.
Ms. Huser, to get back to this consent, why is it that there's just so many cases that people have drugs or whatever on them or in their car, and the officer asks to search, and they say yes? Why does that continually happen? And is the multi-factor test asking the right factors to try to determine the answer? Why do people incriminate themselves like this?
Well, Your Honor, there are lots of reasons that a person could say yes. It could be he's expecting leniency, perhaps. It could be that there's some other crime he's trying to avoid. Plus, with consent, he can control the scope of that particular search. So,
Do you think they're going through all of that stuff in the seconds that this transaction occurs?
well, I think they have the knowledge when they are posed with these yes/no questions that they can say no to that if they would like. So when we look at this, it's the police officer and the individual are on mostly equal footing. And I say that because there was some comparison to trial rights and the sort of protections that we give to people in those circumstances. Your trial rights is a very different situation from on the road, the police officer interacting with an individual. The individual, in the absence of all these coercive factors, which is what the totality of the circumstances is designed for, is to say, well, we presume you knew you could say no, you said yes, did you really mean to say yes? And if it was so coercive that when you said yes, you didn't really mean that, that's where totality comes in, and that's how the defendant is protected in these circumstances.
But it just seems like so much of the research shows that, maybe up to 80% of the searches that occur in this country are consent searches. And are we really digging in and finding out the dynamics of all of that, and that our actual, constitutional principles are reserved for, where we really do dig in to try to determine, the legal analysis, we just reserve that for the remaining 20% of the cases and write off all of these searches that continually occur in all these cases as just, well, that's consent, so.
Well, I think first, when we look at the fact that 80% of these consent searches, 80% of the searches are consent, that doesn't necessarily mean those are the cases that are going forward. We like consent, and the purpose of consent is to balance the two competing interests. It is
Why don't we just ask them? I mean, why don't we just say, and under Schenkloth, it's a significant factor, of course, not determinative as I read Schenkloth, but it's a factor. Gosh, we've got a dozen states that use written consent forms. Iowa Highway Patrol has a written consent form. Police manuals suggest written consent, so you don't end up with the Schenkloth type disputes. It doesn't seem terribly hard, and most of the case law suggests that if somebody does affirmatively say yes, much as in the Miranda situation, the likelihood of overcoming that would be rather small. So, I mean, why isn't it just a good rule to say, look, let's clean up all these totality of fact and circumstances kind of inquiries and just ask for consent? And if consent is granted in 99 out of 100 cases, that's the end of the matter.
Well, I would first have a question for Your Honor. If this was a single factor test, that was the be-all, end-all of whether these consent searches were okay, I don't think that addresses the concern that that's been voiced with, are these people really intending to say yes? Because if you have these magic words, you then are not taking into account the subtle coercion that has come up in some of the cases.
Yeah, I mean, we have that in Miranda to some extent, but if someone gets a Miranda warning, I think it's fair to say, absent some really fairly compelling coercive circumstances, there's going to be a finding of voluntariness. If you had a gun to the head, I mean, the consent would be bad, obviously. But can't we eliminate a lot of these problems by just tightening up the doctrine a little bit? We have a totality of circumstances. Justice Heck may have a different view of the amber lights. I may have a view of, well, it's a country road and whatever. And, so we juggle all these things around and come up with a reaction. That's not a very stable legal test, I don't think.
Well, the lack of single factor, I think, is reflecting the vast difference in factual scenarios that these defendants are finding themselves in. And I would challenge the idea that if we add this requirement, that somehow makes it a better law. I think totality of the circumstances is considering these concerns that we have, because it is allowing the district court to look at all of these factors. Is that a factor? Absolutely it is, but that shouldn't be the be-all, end-all of whether there was consent. I would point again to the distinction between the fact scenario we're talking about and the trial scenario, which is the rationale that Bustamante relied on. And I think that is sound rationale, because when we look at the trial rights setting and even the Miranda rights setting, we have individuals that are in custody, they're being interrogated, they're facing all of these significant constitutional things that are then explained to them by lawyers, by judges, in very in-depth colloquies. The place for that is not in the field with police officers, particularly when, as they're faced with these yes or no questions, they already know, the average person knows you have a yes or no question, you can say no. And to the extent you don't think you can, we do have these other factors that we look at to determine whether it was nonetheless coercive. We would ask this court to affirm. Thank you.
Thank you as well. Rebuttal?
Thank you, Your Honor. Warrantless searches are per se unreasonable. There are exceptions, and if the state wants to assert those exceptions, the state has the burden of proving them. One of the exceptions, the one that's alleged in this case, is consent. An element of consent, or it's akin to waiver, and proof of that is relinquishment of a known right. So the state should not get to skate and bypass what it needs to prove, that there was a relinquishment of a known right. They should have to prove that the right was known, just like when you're doing a plea, just like when you're waiving Speedy, just like when you're waiving Miranda, just like in a contract when you're waiving a breach. You have to know that the breach has occurred before it can be waived. You have to know that you have rights that are being relinquished. There's no reason why this area of the law should get some sort of lesser treatment by this court. In a situation, back to the multi-factor test, in a situation like this, Mr. Prusha had no option but to end up arrested one way or another under this situation. What was he going to do? Try to walk around the officer? Theory and reality.
What's your view? I'm sorry to interrupt you, but I want to follow up on what Justice Zager was asking and see if you have the same view of the facts. What exactly was happening at the time that this, I'll characterize as a search for purposes of the question, occurred? And to what extent was the officer, kind of exercising control or not exercising control?
What I think was happening from the facts, from the testimony that was given, is that after the officer had come back, after doing the warrants check, he wanted to do a search, and they were walking to the patrol car to perform that search. That's the point at which then Mr. Prusha apparently gave the consent and was going to reach into his pocket and to show him what he had, which I think was an effort to garner some leniency, because he was going to show the pipe and hope that this was only a community caretaking situation. He was just checking on my safety. If I kind of show him a pipe, he's going to cite me, and I'll be walking down the road in a few minutes. Because that was the only option he had. If he took to the ditch in the dark, he could get hurt. If he jumped the fence, he's trespassing. If he tries to go around the officer, in the real world, you're going to get arrested for interference. I mean, he had no option but to try to appease the officer.
Now, I understand your argument that maybe the environment is coercive and maybe he didn't know all his rights, but he did have the right to keep walking.
At risk. In the real world, this is where theory and the reality, there's a little discord, because in the real world, officers are going to arrest for interference, or they're going to make a more aggressive, they're going to take a more aggressive position, and they're going to assume that that's some sort of suspicion, which is going to lead them to the next step and the next step. If a person is truly free to go, they would really believe they have those options. But in the real world, in a situation like this, your only option is to appease the authority that's being asserted against you and hope that this is going to go well.
I think we're talking about a lot of speculation here, because I'm not sure we really know what happened here, but what's wrong with the possibility that the officer wanted to have a consent search and would have done a pat-down search, and then he was going to have him get in the car and take him to Marshalltown, where he was walking to? I mean, that would, to me, be the ultimate of the caretaking function. And if it's an officer out there by himself on the road, you know, he's just going to want to be sure, and simply says, hey, I want you to, empty, is it okay if I search you? And without telling him in advance, and then I'm going to let you get in the car and I'm going to take you there. I don't want you walking around out in the middle of the road and in the middle of the night. Isn't that a plausible explanation too?
I guess that's plausible that it could have played out that way, but Mr. Prusha could have decided, I want to continue to walk. Would he have been allowed to do so? Or would he have been compelled to get in the vehicle, at which point we would have had a seizure?
Isn't there, if the issue is psychological pressure, which has been sort of raised in some of these questions, isn't there psychological pressure whether he gets a consent form or not?
If he is told, let's say the officer had said, sir, I want to search you. Is that all right if I do so? You don't have to let me. You have the right to refuse that. And if Mr. Prusha had said, no, I don't want you to search me, then the officer would have had to decide, has this gone, are we in a situation where I can legitimately do a pat down? Even though it's after the fact, I've already determined that I'm safe, I don't have a reason to, but he could have then said, well, I'm going to pat you down for weapons. And we'd be here arguing whether a Terry stop was appropriate, rather than what we're arguing here on a caretaking stop.
But if I may, Chief, and I'm sorry to keep you over, but I think if we adopt your rule, we're probably looking at written consent forms, right?
I don't think it would have to be, especially when you're out on the street like this. I think if somebody's going to read Miranda, they would just
right. But a written form is the only way to eliminate an argument after the fact, or a video after the fact, whether the advisory was given, right?
And correct. And with our technology, I think in a situation like that where the officer, he said he could have turned on, I believe he said he could have turned on his equipment.
Right, which would require the emergency lights to be activated, right?
Yeah, right. And at that point, an officer could easily do that with given technology, or have a card and get an initial or something, even on a citation saying that I consent. I mean, it would be easy to do. And if we're just talking in a situation that's not even crime investigation, where the public's interest should be outweighed by the individual interest, that burden is so slight. And I wouldn't think that this court would say that is such, an arduous burden that we should give this area of the law less protection than other constitutional rights. Thank you.
Thank you as well, Mr. Meyer. The case of State versus Prusha then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.